could even see if we want to count where it start too. So. Is it just us?
Yep. I wish I was invited.
Maybe not. Maybe it's better.
Well, it's
to
my
stay out
case.
here.
I mean, it'd be nice to just listen about what they're discussing,
I'm sure
regards
your
it.
attorney will come and
Yeah, I know
all
that.
about it, so you'll be fine.
How's your day been?
You know, I can't complain. Luis doesn't want to listen to me anyway, so. He asked how my day was. I said, I can't complain. You don't want to listen to me anyway. I could play another video. Maybe later, we'll see.
they usually this long.
Every, you wanna call it, every Thursday, I hate to tell you this isn't abnormal.
I know it's not abnormal, it's just, it feels like my hearing is being held without me.
Quite honestly, they might be even talking about stuff not even related to your hearing is a possibility too.
How is that possible? Everything they're discussing is about my situation, my trial, my life.
Well,
Every
no,
word,
I'm
every
just
word
saying
in there
maybe
is.
there's small talk, because it happens, so. I wouldn't worry about it. And when your attorney comes out?
I gotta listen to him for 10 minutes, relay the story. Like, this is why.
He's your attorney, man.
I know, but if I could just sit in the corner, then cut out the middleman, a lot of waste. If there's small talk, that doesn't even happen.
Well, there is.
I know, but it wouldn't happen if I was in the corner. They would get straight to business and get it over with.
Oh.
Like, I don't mind waiting and being patient. It's just, it feels like a discussion I should be able to be a part of, or at least listen to.
Well, unfortunately, the judges have the
Yeah,
authority
they
to
got the
speak with
authority. I get that.
attorneys, and
I get that,
it
and
is what it is,
I
so.
get I gotta respect and play by
Yeah.
the whole thing. I don't mean to annoy you. It's just the silence is kind of bugging me.
Unfortunately, your hearing's the only one in here this afternoon, so nobody else is sitting in the gallery waiting, so.
You know, I get that. I mean, they kind of, my last hearing, they scheduled it to be the last one on purpose because my case is kind of complex.
Yeah.
It's really in that gray area, if anything.
Mm-hmm.
I think I'm being unjustly prosecuted here, and then the more I kind of push towards trial, the more this stuff kind of happens. But it's just because it's in that gray area. It's kind of my opinion versus their opinion.
Mm-hmm.
How long has Dominic been a judge for?
Oh, I think he's been on the bench for 16 years.
I was gonna say I'm pretty sure it's been quite a while. What was he doing before being a judge?
Was he an attorney or something? Judge? The judge and an attorney or something prior to being on the bench? Yeah, I think so.
Yeah, usually it's the route you go.
Most attorneys in some capacity.
Most prosecutors end up being judges, or at least the ones that strive for
I
it.
hate to tell you, I think there's some defense attorneys that become judges too, so.
Well, it's not like completely uniform, obviously, but if you were to kind of like
But I
say
think
which,
I don't think somebody, goes to school and all of a sudden becomes a judge. I think
no,
somebody-
you need the experience, you need
Yeah.
some sort of record, especially, I mean, aren't judges elected?
Sorry.
Aren't judges elected?
Mm-hmm.
Like, Judge Dahmer gets reelected, what, every 4 years, whatever? I don't know,
I
what,
believe it's 6.
6 years? When was his last reelection?
I don't have that answer for you.
Just curious.
Yeah. If I knew, I'd tell you, but
Yeah,
I don't.
I completely understand. I didn't even know that they were 6-year terms and not, 4-year intervals. So I don't expect you to know everything, but I appreciate it. I don't know, I've heard a lot about Domina in a respectful way, that he's one of the better ones. That was loud. Assuming we'll talk about what just took place afterwards.
Is that?
I'm assuming we'll talk about what just took
Yeah.
place afterwards. All right.
All right.
Ian Allen Olson, 23 CF 1647. Do I have appearances?
Justin Singleton appears on behalf of Mr. Olson, who also appears in person and out of custody. Good afternoon, everyone.
Good afternoon. There appears to be a continuation of an import of the motion filed by the defense regarding suppression of certain evidence resulting from a subpoena that was issued by the circuit court and served on the defendant's residence on October 16, 2023. Registry, like the court did have a brief in-chambers conference with counsel.
Judge, stand by.
I turned it off.
Well,
What's going on?
he's recording.
Turn it
Figuring.
off.
I turned it off.
Is it erased? You can't.
Sorry.
Mr.
I'll hold
Wilson,
on
let me
to
be
it.
very direct with you. I run this courtroom. I don't allow recording without approval. Am I clear?
Yes, Your Honor, I'm sorry.
Right. And don't do it again. If you do, I'm going to find you in contempt, and that's a whole separate issue. Are we clear?
Yes, Your Honor.
Back to the court's prefatory comments. The court did conduct an in-chambers conference to discuss the status of the motion along with the status of trial scheduled for September 30th with counsel for the state and defense. The court is aware that the state may be choosing, as a result of that conference, to eliminate certain counts from the complaint, but as a global statement, I believe the state is maintaining at least an individual count of stalking as a felony level offense alleged, and also criminal damage to property, possession of THC, possession of drug paraphernalia. Is that correct?
Yes.
I'm thinking, were there 3 counts of stalking or 2?
There were a total of 3. There was an amended criminal complaint that added count 6, which was the third
there it is.
stalking.
Thank you. That's why I'm not seeing it. So counts 1, count 2, and count 6 were the original stalking. So the way I phrased it, which the state agreed with, was that 1 count would be pursued, 2 counts would be dismissed, correct?
Yes.
Is the state in position to make that motion today? Does the state want to do it at this jury status?
I'd like to do it as a jury status, please, so I can ensure that we're in full compliance with the notification.
Perfect. So I'll address that, and that would leave, though, one felony level offense, one Class A misdemeanor level offense, one unspecified misdemeanor. Looks like two unspecified misdemeanors with the possession of THC and drug paraphernalia. Now, back to the motion. The court did address with counsel that I had discussed allowing an evidentiary hearing as to the good faith exception potential, as the law indicates that if a search warrant which lacks probable cause at its issuance, but is executed by law enforcement under the good faith exception, then courts may permit evidence seized from that warrant, even though the warrant lacked sufficient probable cause under the Fourth Amendment to be used at trial. My review of the case law regarding that standard doesn't require an evidentiary proof, but really the court is permitted, and I think most courts do, according to my review of the records, rely upon the record established regarding the information that was provided and the basis for the warrant, which is also what apparently the U.S. magistrate did in the United States District Court in the Eastern District in document 77 at page 15 of the decision in that court, which resulted in reviewing the same warrant that this court has here, the suppression of that information seized based upon the lack of probable cause, but also based upon a conclusion of the faith exception as a matter of law could not apply. Ms. Thompson had written the court asking the court to adjourn today because of the unavailability of the fact that this witness had this court declined. It holds the legal argument that the state is unable to present factual testimony. Part of the reason this court declined that was because of the number of times this case has been adjourned, and the pressing trial date in this case of September 30th with the jury status scheduled for next week. Although Ms. Thompson indicated in her letter that she had acquired the calendar of the witness who was undergoing some medical procedure. My court calendar is stacked through the day of this trial. So I did not, and I had set aside an entire afternoon here on this case to deal with this issue. So I denied the request for adjournment based on that. As I understand from Ms. Thompson's comments in chambers, the state will not be pursuing because the witness is unavailable in evidentiary record. Is that correct?
Correct.
But the state would like the opportunity to argue the issue legally, correct?
Yes, please.
And because the burden rests with the state, I will hear first from the state, and then I'll hear any legal argument from Mr. Secretary. And I will reach conclusion. Ms. Thompson.
Thank you, Judge. In making my arguments to the court, I rely mainly on United States versus Leon, that's 468 U.S. 897, with a 1984 decision, and also State versus Eason, E-A-S-O-N, 245 West 2nd 206, is a 2001 Wisconsin Supreme Court case. In the Eason case, the Wisconsin Supreme Court adopted the good faith exception to the exclusionary rule as outlined in the Leon case, but also added two additional factors for the state in order for the court to make a finding that the good faith exception should apply. I would note that the exclusionary rule cannot be expected and should not be applied to deter objectively reasonable law enforcement activity. The mistake, if any, would rest with the judge or magistrate who issued the warrant, and suppression would not have a deterrent effect on law enforcement if they acted objectively reasonably. In looking at the Leon case, it does list 4 different situations in which the good faith exception should not apply to the exclusionary rule. Or I'm sorry, if the court should not apply the good faith exception. The first is if the magistrate was misled by information in an affidavit that the applicant knew was false or would have known was false except for the reckless disregard of the truth. At the last hearing date, the court denied that portion of the defendant's motion and did not find that there was a material omission of any fact. The affidavit that was submitted by Mr. Olson was filled with numerous complaints, but nothing that rose to the level of a Franks-Mann violation. The second scenario in which the court should not apply the good faith exception is if the magistrate wholly abandoned his judicial role. I don't think that there is any evidence in the record to suggest that Judge Carter completely abandoned his role as a neutral and detached magistrate when he was reviewing this warrant and affidavit by Detective Foster. The third situation is where no reasonably well-trained officer should rely on the warrant because it is so lacking in indicia of probable cause. And the final situation is whether the warrant was so facially deficient that the executing officers cannot reasonably presume it to be valid. As I noted in my written response to the court, to the defendant's motion to suppress and for a Franks-Mann hearing, I do think that based on the information that is in the affidavit of this search warrant, the officers did or objectively believed and it was reasonable that this warrant was supported by probable cause. The 2 additional factors in the Easton case is that the state must show the process used attended to obtaining the search warrant included a significant investigation and a review by a police officer trained in the legal vagaries of probable cause and reasonable suspicion or a knowledgeable government attorney. The affidavit in this case was reviewed for legal sufficiency by attorney Christina Gordon. She is no longer with our office, but she has handled many cases when she was employed with the Waukesha County District Attorney's Office. She has signed numerous warrants. I believe she was in the office at least 6 years and should be considered by this court to be a knowledgeable government attorney.
She was a deputy district attorney.
Yes, sir. When we look at the other Easton factor, which is where the state must show significant investigation, I think that is outlined in the affidavit of the search warrant. Detective Foster has been a sworn law enforcement officer for 22 years. Actually, I would say 20 years because his warrant is from 2023, my apologies. He puts the history that his department has had with Mr. Olson in the affidavit. He indicated that the time frame of this investigation and all of these incidents was from March 15th of 2021 through October 5th of 2023. Detective Foster noted or started with the incident at the Pewaukee Armory where Mr. Olson was subsequently convicted of battery to a service member when he was federally indicted for his conduct there. The affidavit details contacts that Mr. Olson has had with the Armed Forces Recruitment Center on Blue Mound Road. It continues on to describe the criminal damage that was done to government property, as well as both vehicles and relating to damage to vehicles.
The tire issue.
Yes, the tire issue, but also vehicles with U.S. government license plates parked in the rear of the address had the words Nazi dog and swastikas drawn on the windows in marker. There is in paragraph 8, Detective Foster references a text message that he received, or that Sergeant Nance received from Mr. Olson. Mr. Olson in that text message discussed paperwork being filed that would, quote, seal Nance's face. Then we have additional criminal damage to property complaints that are noted in this affidavit, one of which the court noted was the knife in the tire. The knife was still in the tire by the time officers arrived. There was a incident where there was spray paint on the front door of the Army recruiting door that stated civil rights violators and self-identified as a domestic threat. The Marine recruiting door just down the way was painted with "This is where patriots are made." Eventually, Officer Kaneline, there were several incidents together, and then eventually Officer Kaneline actually caught Mr. Olson on scene. And that incident is noted in the affidavit as well. Upon the defendant's vehicle being searched by law enforcement on September 5th of 2023, officers located an orange painted AR-15 style paintball rifle. The affidavit also discusses that Officer Pitt made contact with the individual who's identified in the criminal complaint as victim A, and I'm looking at paragraph 13 on page 7. Detective Foster noted the text messages that had been sent to victim A by Mr. Olson. Officer Pitt also spoke with another individual who had received text messages from Mr. Olson, and those are documented in this affidavit. Detective Foster, in his 20 years as a law enforcement officer, also talked about in his affidavit about how people rely on their cell phones and they use electronics, and there is a significant amount of data that can be recovered from these electronic devices. That takes up paragraphs 17 through 28. And then at the conclusion, which is paragraph 29 of the affidavit, is where Detective Foster talks about why a review of this defendant's electronics that could be recovered from this residence are necessary to investigate the stalking. We already know from Detective Foster that this investigation of Mr. Olson, whether it was only restarted, if you will, once incidents were reported, but we see the evolution of Mr. Olson's conduct through the affidavit. So I think that the Ethan factors, that significant investigation be done, I think that is outlined in the affidavit by Detective Foster. For all of these reasons, Judge, I do think that the good faith exception applies in this case to the exclusionary rule. I don't think this affidavit falls into any of the 4 incidents that the Leon court stated the good faith exception should not be applied to. So for all these reasons, I am asking you to make the finding that the good faith exception to the exclusionary rule applies. Thank you.
So the analysis on this risk management is that between the alleged crime and the property sought to be searched. And the U.S. magistrate referred to as not an area of conservation access was demonstrated. As I understand, one observation of the warrant, which was based on the granting was a statement in the affidavit that the crimes being investigated were stalking under a bail judgment, and that the property sought to be searched, while identified by address, was not clearly referenced as related to the defendant. There was no statement to what the relationship was between this property and the defendant alleged by the accused. It was simply a property that was identified. I wanted to ask you, just in light of our analysis, I believe you're arguing that I should disagree with the magistrate that there was no sufficient nexus. Just kind of throw that I think specifically from the state's perspective based on this matter.
Yes, Judge, I am asking you to not follow the magistrate's determination as to that issue, and I would rely on all of the bullet points that I listed out in my response to the defendant's motion to suppress. That is on page 4, and it lists all of the reasons why I believe that there is a reasonable conclusion that this residence is connected to Mr. Olson, and I believe that is a sufficient nexus.
In fact, this residence was Mr. Olson's, this location, this structure, this apartment that was sought to be searched, was Mr. Olson's residence.
Yes. I would also note that, in particular, the affidavit discussed that the Pewaukee Police Department searched Mr. Olson's apartment one day after the Pewaukee Armory incident that occurred on March 15th of 2021, and that is referenced in the report as well. I understand it does not specifically say 4670 Woodfield Court, apartment 7, but I think it is significant that what the residence we searched was an apartment, and Village of Pewaukee had previously searched Mr. Olson's apartment specifically related to the Armory incident that Detective Foster references.
Under a separate warrant. They searched under a separate warrant.
Yes, because that was back in March of 2021, yes.
That warrant's not an issue. It wasn't reviewed. It wasn't part of the
There isn't a warrant. There isn't a warrant.
Correct.
For March 21.
Yeah, that was a self. My wife let them look around.
Within the search history of this defendant, the same property, ultimately factually.
Yes, that is a reasonable inference I am asking the court to find from that particular point.
It could have been that Mr. Olson lived in 2 different places within that time period, right?
That is a possible innocent explanation, yes.
But the reference by the state today is that it's supposed to be the same.
Yes.
Okay, anything else the state wants to say?
No, thank you.
I do want to find your response. Thanks, Mark.
I probably put a response.
Thank you, Your Honor. The state, I think, immediately outlined the exact cases that I was looking to rely on as well, and read many of the significant same portions, Your Honor. Turning to, obviously, the court has determined that we are not to introduce evidence as to the good faith or the knowledge of the officers as to whether or not there was any false statements within the affidavit. Your Honor, I would just note, though, that we did specifically bring up, in reference to one of the areas that the state just brought up, the claim that the paperwork that was handed over would seal the individual's fate. The fact that the officers did not reference anything that was all in service of a subpoena related to ongoing litigation, that was the whole purpose of that interview. We did find that was dishonest, but the court disagreed. So, Your Honor, I think that now to go turn around and then take that statement and argue that it's actually evidence of stalking is kind of having it both ways there. As to many of the other, well, Your Honor, first I would note, since we've discussed the magistrate's decision, obviously the defense agrees with it. We agree with it in several substantial areas. First, as Your Honor noted, that there's no nexus whatsoever between Mr. Olson and the apartment in which there is an attempt to search. In all of the cases that are discussed here, and in the cases that are discussed by the magistrate court in its decision, there was a request to search a location. And so the mere entry of a location in a request to search does not establish the nexus between the individual and that location. The state's only evidence alleging that there is a nexus between these two locations, as far as I could tell from everything that they just said, is a single statement about a different search of an apartment more than 2 years prior, and an assertion that they searched his apartment by consent 2 years prior. That's why there was no warrant, Your Honor. Does not establish Mr. Olson's attachment to this location. Additionally, Your Honor, the state looked at a lot of evidence, discussed a lot of evidence that I believe that they are admitting as to try to show that the officer who was involved here law enforcement conducted a intensive investigation, and that they were knowledgeable about the law and the nuances of the law. However, Your Honor, I would note that in the state's recitation of facts, much of what the state asserted was evidence of the exact thing that the magistrate discusses, that stalking is conduct that is directed at a person. And the state talks about prior battery to a government agent. That has nothing to do with any of the individuals here who would be allegedly stalked. Contact at that location. Again, that seems like it's clearly indicated to be evidence of conduct targeting a location, not an individual, any particular individual, which is specific and required to stalking. And in fact, the affidavit goes way before and includes lots of information which maybe sullies Mr. Olson, but doesn't have any impact on, or doesn't tend to demonstrate that he was directing conduct at a particular individual. Similarly,
stalking requires 2 or more course of conduct, which is defined as 4 or more qualifying acts demonstrating a common purpose, unified purpose directed towards an individual. It doesn't require that there be that all acts be individual specific. And let me just say that differently. Conduct directed to inanimate objects, property, can qualify under the conduct definition for stalking. Do you agree with that or disagree?
Yes, Your Honor, I believe it.
So I'm confused by your argument at this point, because what you just said was that the state has done nothing more than allege that there's certain conduct directed towards property, and that's not the individual. In order to start, you have to have matters directed toward the individual. Can't it be both?
It could, Your Honor, but I think that the fact that going on there was damage to a variety of vehicles belonging to the government, not vehicles belonging to an individual, but belonging to the government. There was discussion of paint on an Army recruiting door and a Marine recruiting door, conduct that seemed to discuss specifically, make political or make disparaging statements, however you want to interpret them, about the armed forces, that the damage to property was alleged to be damage to property, Your Honor, but not property belonging specifically to the individuals who were alleged victims of stalking, not a indication that the victims 1, 2, and 3, their relationship to those vehicles or those particular locations or those particular doors. And so we have a broad recitation of observed alleged investigations, but when it gets to the nuance, Your Honor, and the ability to demonstrate whether those facts are more than just things that are interesting or that a court might not like about Mr. Olson, but whether they actually establish probable cause, that there is going to be evidence of particular violations found at a particular location in relationship to Mr. Olson. And I think that most of that goes to potentially an investigation of criminal damage to property. However, as the magistrate noted, there's no attempt or no argument within the affidavit to assert that the law enforcement believed that there was evidence of criminal damage to property at that location. And so we have a long recitation of facts, but few, if any, go through the demonstrate a pattern, a course of conduct directed at an individual. And I think it's actually pretty clear that these are just individuals who were interacted with while there's a course of conduct directed towards the government facilities. Your Honor, that isn't ultimately the only issue that we're seeking to note, but it does demonstrate that we haven't had any testimony from any officers about their level of training or their level of understanding or their investigation. The state chose to rely solely upon this affidavit and what this affidavit shows as to the level of training and the level of knowledge of the law enforcement and the deputy district attorney who signed at the end. Besides the signature by the deputy district attorney, we have no other evidence as to what was undertaken in that regard, Your Honor. So I don't believe that the affidavit establishes, I guess is my point, the standard that is required independent of the federal standard under the Wisconsin Constitution, and that is the establishment of this significant investigation and a review by a police officer trained in or very knowledgeable of the legal vagaries of probable cause and reasonable suspicion, or a knowledgeable government attorney. So, Your Honor, if we're relying solely upon the affidavit for that determination, I think that what we have is kind of a scattershot of things that might encourage a court to not like Mr. Olson, but very few of which go to establishing a nexus between crime, place, and Mr. Olson. So, as the magistrate notes, we have no evidence in the affidavit establishing any connection between Mr. Olson and that place. And we have evidence of criminal damage to property, but there's no request or indication that evidence of criminal damage to property is going to be found at that location. And so the sole part that is left remaining that there's any evidence of is perhaps that there would be evidence of some offensive stalking that would be located at that location. And yet, Your Honor, that stalking evidence does not seem to the extent that the state just went through it, is incredibly weak. when it comes to establishing the actual crime of stalking, which requires a course of conduct directed at a person. It is if anything, the opposite inference is created by that evidence, and that this is an individual who is upset at the government, is upset at the military, has a problem with military, and that is why it is protesting at that location, contact at that location, law enforcement contacts with them at that location, damage to a variety of government vehicles at that location with government license plates, damage to 2 different military recruiting offices, not specifically tied to the alleged victims necessarily, and then just individuals who he, throughout those things, interacts with. So, Your Honor, I don't believe that there is, to the extent that there's a nexus to criminal activity, as the magistrate agrees, that is de minimis at best, to the extent that it even exists, and that certainly there's nothing that overcomes the reference to a prior search years prior at his apartment by consent does not establish any connection between the defendant and this location. Your Honor, I think ultimately what the court is getting at is that officers should not try to overwhelm or sneak things by the court or put things in that, that where they know that they never quite got there to establishing that this even was his location, or they understand that they don't have a very clear stalking charge, so they put in other information that seems like it's relevant and, helps them to somehow get to a place. But then when you look at it, very little of it is actually tied to the alleged crime, the only alleged crime that they were, at this point, able to go ahead and investigate. Additionally, no reference to him being on bond at the time of any of these acts to establish a crime of bail jumping. So, Your Honor, had the court been, had there been an evidentiary hearing, I would have asked questions specifically to what the officer's understanding was of the offense charged here, the alleged offense as to stalking, what the officer was looking for, and why he believed that this evidence which he listed in the complaint or in his affidavit was indicative or suggestive or demonstrated the crime to which he was engaging in occurred, and whether the officer would have understood or demonstrated an understanding, I don't know. That's why we have evidentiary hearings. We can't guess at it, but I think it's likely, given this record, that the officer would have struggled to identify the difference between conduct, which, as Your Honor indicated, could be in different circumstances, which is geared towards the property of an individual, for instance, or geared to attempt to harass or intimidate an individual, and conduct which merely happens in the individual's presence. So I don't think that we've established good faith here, Your Honor. We haven't had any evidence establishing good faith. We haven't had any evidence establishing the skill or experience or expertise in as needed under the Wisconsin Constitution. We haven't had a nexus between Mr. Olson and the location. We haven't had a nexus between Mr. Olson to the location and a particularized crime. And so for those reasons, Your Honor, I would ask that the motion to suppress be granted.
One of the reasons that I indicated to the two of you, and I'll place on record at this point, that Dr. Staff would go forward today to argue the issue of good faith exception, was that the court had denied the motion for Frank Span review by the defense, and there was not sufficient required initial demonstration to allow for the probing law enforcement regarding construction of the affidavit and the omissions that may have occurred. And counsel has indicated, well, there wasn't an evidentiary hearing here, and so then limited by your capacity. It is a correct statement. The state is relying upon the filing of the affidavit as a demonstration of what it is arguing is sufficient basis, which this court has also reviewed. I believe that it is not improper for the state to make that argument. And I believe that an evidentiary hearing could have occurred, but the fact that it didn't occur doesn't necessarily compromise the ability of the state to ask this court to review whether its exception applies. So I'm quite satisfied that this could proceed today based upon the paper record with the references that we've established. So just as an observation to your last comment, that was the reason why I felt that this matter could proceed on the record as it exists. And I believe I also indicated that I was concerned by ruling that the defense had not met its evidentiary burden to be eroded, and that any evidentiary hearing potentially would start looking a lot like exactly the hearing that holding the officers using for their construct of the affidavits and how they were constructed. So I'll stop it there. Ms. Thompson, you had made a reference to a large statement by the defendant regarding I think it was to alleged victim A. Use my wording, something like to that effect, but I'm trying to find where you were referencing that. I've been looking at paragraph 13 of the affidavit where you made an additional argument. Were there other parts? Or is it in the criminal complaint allegation?
Double checking before I answer. Oh, in paragraph 8, but it was specifically sent to Sergeant Nance, not victim A.
Sergeant Nance, the law enforcement officer? Oh, no, the other, is this the other alleged victim?
Yes.
This would be victim B?
C.
This would be victim C. Paragraph 8, where the allegation is that the defendant, I know there are not quotes around this.
No.
This is a descriptive characterization by a writer.
Yes.
The message made reference to a violation of health and first and fifth amendment rights as well as physical being found to seal Nance's fate. That's victim C.
No, thank you. I don't have anything additional.
Return on this warrant show what was seized.
on October 17th, at 10:15 a.m. And what it says is see attached property inventory receipt, sheet. Let me back up. The premises was searched on October 17th. The return is filed with the court, with the clerk of court, on October 19th of 2023. There is